Good morning. Happy Wednesday, part 2. Got a little bit of time on my hands this morning, so I figured we'll cover a discussing law video. He's banging them out. Let me just read them ahead of time. Let's see if I get these right. Let's see if him and I agree to these statements as he has them written here. Number 1, there is no attorney-client privilege in an action unless the attorney has made an appearance. That is false. The attorney-client privilege attaches when the client talks to the attorney or the attorney talks to the client about the case, about the potential legal issue. It's like if a client goes to an attorney and says, hey, someone's suing me, can you help me? The attorney says, what are the facts of the case? The client says the facts of the case. Then the attorney says, no, I can't help you. The attorney-client privilege is still attached. There's still attorney-client privilege there. The attorney can't go and start talking about what the client told him, even though the attorney hasn't made an appearance. So it's not dependent on the appearance. It's dependent upon whether there is an attorney-client relationship. Number 1. Number 2, whether or not they've had any discussions, whether the requested evidence is, is there an attorney? Is there a client? Have they talked? Whatever they've talked about is protected. All right, the second thing, he says, only attorney-client communications are privileged. No, there are lots of privileges. California has the marital privilege, like the state can't force a wife to testify against a husband and things like that. There's the petitioner penitent privilege. There's the psychotherapist patient privilege. I mean, there's a bunch of privileges. So that's wrong. So the first two are wrong. This is easy. I think I'm going to get 100% on this one. There's no need to submit video evidence to the court. Well, okay. There's no need to submit video evidence to the court. Let's see about this. There may be a need to submit video evidence to the court. Like if you're doing a short cause hearing and you're no, because need. See, normally in my practice, I don't normally submit video evidence to the court. I don't believe I've ever submitted video evidence to a court. I have, like for contempt things and things like that, I have submitted transcripts of videos to the court with the relevant portions highlighted from a transcript company, from like a court reporter company that does transcripts. And then any images that I need off of it, I've put still shots in. I assume there may be some situation where you would need to use the full video, but normally the full video would be something like that is more for trial, where you play it at trial and then you can submit it at trial. So, and I guess you would submit it to the court at that point. So yes, there will be a need, like at trial, to play a video for the jury or for the court, and then you would submit that to the court as evidence. Yeah, so I can see that. Lawyers like to argue and never admit to being wrong. Most lawyers do like to argue. There are a lot of lawyers who don't like to argue. Like there are a lot of bankruptcy attorneys who won't do any I forget what they call it, where there's a contested bankruptcy. But basically, you could have like little lawsuits within a bankruptcy action, and they won't do that. And so there are a lot of lawyers who like bankruptcy because they don't have to argue. It's just basically processing paperwork. There are a lot of lawyers who work for big businesses in their legal departments, not actively engaging in litigation, in arguing, but in reviewing laws, making sure that you're in compliance with various regulations, etc. So I would say most lawyers like to argue, but not all. And never admit to being wrong. I don't know about that. I certainly have admitted to being wrong. You could go through my video list and you'll see plenty of mea culpas in there. Leonard French has a saying, it's best to eat crow when it's young and tender, or else you'll surely eat it when it's old and tough. And that's basically saying admit that you're wrong when you're wrong. We're required to admit that we're wrong to courts or to the state bar. A 473B motion, if the attorney throws himself on his sword, you can get judgment set aside for attorney mistakes, and I've seen attorneys do that. So I'm going to say that's wrong. I mean, anytime you're really phrasing things like this with absolutes, you're going to make the statement false. Because if you said most lawyers like to argue and most lawyers don't like to admit to being wrong, I would say that would be more true. But this is wrong as stated. So false, 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 false. Okay, let's see how well I do.
So I got some more common legal myths for you. So the first one is, there is no attorney-client privilege in an action unless the attorney has made an appearance. So this comes from Murphy's reading of Chili's document the other day.
That comes from me. Well, this is news to me.
Where he said, I don't know, he referred to some discussions with his legal team, where he says, well, that's going to be discoverable by the opposing party now, and it's not protected because there's no attorney that's filed an appearance, or something like that.
Or something like that. Okay, so it came from your misremembering things that I said. I believe it is Mark Adams. Communications between Chili and Mark Adams, and communications between Chili and discussing laws. Since those aren't attorneys, then yes, they are discoverable. The attorney-client privilege, once again, protects communications between the attorney and the client, back and forth. Now, that protection extends, like say that I'm representing you and you tell my secretary, hey, can you tell John X, Y, and Z? Well, because she's part of my staff, it's protected. It's part of that blanket of attorney-client privilege. But there has to be an attorney in there. And ghostwriting is not allowable in Massachusetts. They don't allow that in the first district court, in the first circuit. They don't allow ghostwriting. So there's no attorney in there. So, and even if there was an attorney in there that they had talked to, it doesn't all of a sudden blanket everybody's statements about everything. Just because there is an attorney in there, it will still only cover communications to that attorney and back from that attorney. Unless the attorney has people on staff, like if Mark Adams, I think his name is Mark Adams, and discussing laws, assuming they're two different people, they may not be. Chili never CC'd Mark Adams and discussing laws in the same email. So good job, Chili. So they might be the same person. But anyway, regardless of that, if they were employed by an attorney, and if Chili was discussing it with the attorney, if Chili had some sort of a relationship with the attorney, then sure. It doesn't have to be that Chili has retained that attorney, but if the attorney's volunteered the services of his staff, that might be protected. You're getting closer there. But in order to assert the attorney-client privilege, one of the things you have to have as part of that assertion is a freaking attorney. You need the attorney. You have to say, Normally it's the attorney who's going to be asserting it, but I'm assuming in this case it would be Chili that's asserting it, and he's going to have to name the attorney. He's going to have to say, I have an attorney, and I'm not going to turn over these communications with Mark Adams or discussing laws, assuming they're different people, because it's protected by attorney-client privilege. It's the onus is on Chili then to establish that there is an attorney-client relationship there. So that's going to be a real problem. And I strongly suspect that unless this thing gets dismissed, all of those communications are going to be discoverable, and real identities are going to be discoverable. So discussing law, if you're pooping your pants a little bit, well, you're playing the game, buddy. You're gonna get hit if you're playing the game. Just letting you know.
Yeah. So that's not true. You could definitely ghostwrite all of Chili's documents and still have attorney-client privilege.
Not in the First Circuit. If you're going to assert that an attorney is ghostwriting your documents, you're going to have to turn up that attorney, because they don't allow that in the First Circuit.
The major thing that determines whether your communications between you and an attorney are pillaged is whether
between who? Between who? Oh, between you and an attorney? Oh,
contents of the communication is primarily legal opinion, legal services, right? So
is Mark Adams an attorney? Is Mark Adams an attorney? That's the thing that I was pointing out. Mark Adams is an attorney. You're not an attorney, despite your claims to be a member of a bar of 2 states. I mean, put up or shut up, son. It's really weird. It's really weird. All the attorneys out there on YouTube with their little YouTube channels, you know who they are. Like Leonard French. Who's Leonard French? Well, he gave you his name, dude. Like, he's not hiding it. I've given you my name, John Rietville. I'm not hiding it. Robert Barnes, Rikita, whatever, Nick Rikita. There's all sorts of attorneys out there. There's all sorts of attorneys out there, and they don't hide their names. You can find out who they are because they're actually attorneys. Discussing law, not an attorney.
So, for example, when Merbeast was trying to say that his Wicker discussions with Kate were going to be privileged, but the motion for sanctions from Chile said that the contents of the communication were mixed content at best.
So, slight correction there, Sparky. When I was saying that any alleged communications between me and Kate, if they exist, which they don't because I've never used Wicker, I hadn't seen the alleged communications between me and Kate. So I didn't know the content of them. I was assuming when I made the statement that if there's any discussion of law in there, who knows? Who knows what these things are? But then when you produce them, or when Chili produced the alleged discussions between me and Kate, number one, it became very clear that those were fabricated. And no, I don't use Wicker, so sorry, Charlie. And good luck on the motion for spoliation. Oh, wait, it was denied already. So, yeah.
Which means they're a combination of legal stuff and non-legal stuff. So
the way the attorney-client privilege works is if it's already out there, you can't assert the attorney-client privilege. Like if someone says, I have these documents from them, and there you go, court. You can't say, wait, those have attorney-client privilege information on them. You can't do that. It's a defense against producing the documents for like discovery, or producing the statements, or revealing the contents of the discussion. Once opposing party has them, its attorney-client privilege is irrelevant. So when Chili walked in and metaphorically walked in and slapped down the Wicker communications on the table, attorney-client privilege wasn't an issue. He already has the communications. It's not like if they were for me. Let's just arguendo say that those communications were for me, and let's arguendo say that they contained protected attorney-client communications. Let's just say that arguendo, right? Let's just pretend it. I can't at that point say, attorney-client privilege, because he already has them. But if he tries to send a deposition notice, whatever, let's say that I am representing Kate, and let's say that they are looking for communications between me and Kate, I would then assert the attorney-client privilege, and then the onus would be on Chili to try to defeat that.
Let's move on to the next one. So only attorney-client communications are privileged. That's also not true. Right? Otherwise, you couldn't trust sending any documents to your paralegals and legal assistants and researchers and expert witnesses. Otherwise,
Well, okay. So expert witnesses, the discussions between the attorney and the expert witnesses are not attorney-client communications because you'll notice there's no client involved in that. That's work product. A lot of the things you're talking about are attorney work product, but the attorney can communicate with his staff and still maintain the attorney-client privilege. External things is going to be usually work product, attorney work product. But again, I hate to break this to you, discussing law, but these both turn on attorney work product and attorney-client communications, both turn on there being an attorney involved.
right, instantly discoverable. So either where Murphy's practices law, they don't have work product doctrine.
So yeah, who is mixing up attorney-client privilege with the work product doctrine? Oh, would that be the non-attorney discussing law?
Which I doubt, or he's just not familiar with it.
Yeah, I'm not familiar with it. Says the guy who's confusing the attorney-client privilege with work product doctrine.
So attorney-client privileges are not the only privileges recognized in court. There's also work product privilege, which is basically documents that have to do with your litigation that specifically discuss strategy and stuff like that that don't need to be disclosed to the opposing party. So
That generally don't need to be disclosed. There are exceptions to the attorney work product doctrine where if the opposing party can show that it's like necessary to get that stuff, like let's say one attorney had let's say there's a bad accident and the company that thinks they're going to be the defendant hires an attorney who says, okay, I'm going to have someone inspect the accident scene. And that guy goes out there and inspects the accident scene and gets all the measurements and everything like that. And then, great, brings it back to the attorney. And then the defendant cleans up the accident scene. And then plaintiff sues and says, hey, we want to inspect the accident scene. And defendant says, oh, sorry, we already cleaned it up. Then the plaintiff might be able to get the attorney work product, i.e. the inspection results of the accident scene. They might be able to get that if they show that it's like necessary for their case and yada yada. So you can get past the attorney work product doctrine if absolutely necessary. Like if the plaintiff or if one of the parties shows it's just absolutely necessary. So it's not a complete shield, but the attorney-client privilege is privileged.
the next one, so I guess there's one thing to say about work product privilege though is the privilege is not as strong as attorney-client privilege. So attorney-client privilege survives
Oh, wow.
death of the client. Attorney-client privilege cannot be defeated by argument, whereas work product privilege can. You could argue that you definitely need access to those work product privilege, or it's going to be miscarriage of justice, which is unlikely to occur, but in theory.
I want to say that I have not watched this video, so I am spitballing here, and it's almost like I'm an attorney and I know my shit at 8:30 in the morning, not having had coffee yet.
Talking about theory, that can happen. All right, so there's no need to submit video evidence to the court. So I know Murbies and then tons of comments too are saying like, why is Jilly trying to submit video evidence to the court? The court doesn't need that. Well, that's not correct. So in fact, if you look at some of Ben Wish's affidavits, he talks about carrying thumb drive with the videos to the court for further review. So could it be that Ben Wish that's involved in this federal lawsuit doesn't know what he's talking about, or maybe Murbies doesn't know what he's talking about?
No, there's no need to. You can submit a transcript to the court with the relevant portions highlighted, and courts generally tend to appreciate that, especially if it's a 2-hour plus video. The court just needs to have the information in front of it, the necessary information in front of it in order to make the decision. And if it is a video on YouTube, you could just submit the URL links. And I've never seen Benjamin Wish submit a thumb drive to the court. So maybe I'm wrong. Maybe it's Maybelline. But no, there's no need to. I don't think it's best practices, and I would argue with Benjamin Wish. I have disagreed with a lot of what Benjamin Wish has done in this particular case. I'm not saying that he's doing anything wrong. I'm saying he's doing things different than I would have done it, but, those are differences.
So I'm arguing the latter. So you should, if you reference of it.
So wait a minute, if Benjamin Wish is so awesome, and Benjamin Wish thinks that you have a shit case, then what?
You should make it available to the court for review. And then,
Make it available to the court for review. It depends on if it's relevant, if it's necessary, etc. I think a lot of the times the bullshit that Chile does is he's just trying to do the spaghetti method and throw a whole bunch of shit at the court, expecting the court to review everything ahead of time. But no, it's not necessarily necessary to submit it. And the only time you would submit it to the court before trial, when you're submitting it as an exhibit, having it introduced into evidence, which is the correct term, having it introduced into evidence, not submitting it, but whatever. But in a pre-trial kind of motion hearing, if something on there is necessary for you to get the relief you're requesting, then yes, you would submit it if that's the only way you could do it. But it's preferable to do a transcript. The court would appreciate a transcript. So do you need to? No, you don't need to. You might want to if you're lazy, but you don't need to. And again, if there's no pending motion, then you don't submit anything to the court, evidence-wise.
You're also required to provide a copy of the video to the opposition.
Well, you don't have to provide a thumb drive of it to the opposition. If it is a URL, you could put it in your pleading and they could watch it online. Or again, a transcript, which is still the preferable way.
But it is also weird that, according to what Shelley says, the clerks have not told them what format they prefer, because they should do that. I usually default to DVD if they don't answer, but they should answer. Because, if Ben's submitting thumb drive, obviously he has some added benefit of knowing what's going on and that they're not sharing. So the final final legal myth is lawyers like to argue, never admit to being wrong. So that is actually not a myth, that is completely true. We like to argue, and we're never wrong. We just will continue.
Oh, you're an attorney now, are you, discussing law? Bullshit!
Adding argument that shows why we're right, and find edge cases. So we're never wrong, yet we'll learn from our mistakes. So I'm hoping that that's the case with Morbius when he hears about these cases where he's wrong. He's going to argue edge cases, and that's not what we were talking about.
I'm arguing edge cases, and that's not what we're talking. Well, yeah, I mean, you generally don't address specifically the topic that I bring up, but that's fine.
But when he goes to apply this, he will remember what he learned. For example,
I don't learn anything from you discussing law. I hate to break this to you. I don't learn anything from you.
When Ben Wish early on in this case submitted some evidence that did not follow the rules of evidence, and then Chile pointed it out, and Ben, of course, was not going to admit that. But then in his next filing, he did not make the same mistakes. So lawyers like to
What? I don't know what he's talking about, but okay.
If you like to argue, you should become a lawyer. So that's what I got. Have a good one. Bye.
Well, if you are a lawyer, sir, we'll probably be finding out about it if they go to discovery. We'll probably be finding out about it. And then your little doxing thing. Uh-oh. Thanks for watching. Have a great day.